So remember when Paul O'Keefe thought it would be a good message to send to the jurors during closing argument to invite along Jed McCabe, Colin Albert, and his uncle, Brian Albert, to sit with him and his family?
During closing arguments, he invited some of the people the defense had tried to implicate in his brother's death to sit with his family.
It was just our way of saying, we don't believe in any of this stuff.
Only that wasn't the message that Brian Albert sent. Oh no, at least not according to one juror. The whole jury, quote, felt very intimidated by Higgins' presence at the end. Higgins meaning Brian Albert. Now, my question is, and I understand it's hard to confuse one meathead for another, is this the final stare down? Hello, and welcome back, roommates, to Alexa's Room, where we are not lawyers, we are not medical professionals, and we are not law enforcement. We are just people. We are people who have opinions about all things going on in the Karen Read case, because that is what we have been covering exclusively on this channel for the last several weeks. This motion in limine that was filed earlier today by the defense. Thank you, Karen Read Updates at Karen Read is Innocent, for sharing. If you want all the latest and greatest motions that are filed in real time and you're on the Twitter X's, make sure you follow this account because they are always on it. Defendant's motion in limine to exclude certain witnesses before and after testimony. So now comes the defendant, Karen Read, Miss Read, and respectfully moves this honorable court, must have been gritting her teeth while writing that, in limine to exclude certain witnesses from the courtroom before and after their testimony at trial in this matter. So sorry, Paul, you might be sitting with your wife, maybe soon to be ex-wife, who knows, and your mom, Peggy. I didn't even see John Sr. O'Keefe on that exemptions list. That was another motion filed by the Commonwealth of family members. So, and it does seem that Hank Brainen is okay with allowing the Reads as well, too, to stay in the courtroom. They will not be sequestered after their testimony, before or after their testimony, from appearing in the courtroom. So, I mean, that's good. I don't see why they would be denied that by Beverly Canola Oil, but, let's see, especially because I don't think they're going to be called as witnesses because Brainen didn't get what they wanted anyways, right? He didn't get those phone records from them. So, Rule 21, sequestration of witnesses of the Massachusetts Rules of Criminal Procedure says that, or states that, upon his own motion or the motion of either party, the judge may, prior to or during the examination of a witness, order any witness or witnesses other than the defendant to be excluded from the courtroom. Mass or crim, yada yada. The power of a judge to control the progress and within the limits of the adversary system's shape of a trial is universally held to include the broad discretionary power to sequester witnesses before, during, and after their testimony. I just remember how striking it was to see Brian Albert and Jen McCabe. They made the whole internet feel uncomfortable with those stares. Like, those were mile-long stares. It was really, really, really uncomfortable to watch, and I can't even imagine being the jurors, considering they were right across. Now, what's interesting is a lot of this is redacted. It's not a very long motion, but you can see there is a chunk of it that is redacted, so I'm curious to know what that might be about. But anyways, continuing on. Miss Read specifically requests that the court exercise its broad discretion to exclude Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jen McCabe, Matt McCabe, and Brian Higgity Diggity from the courtroom before and after their testimony at trial. I don't think Brian Higgins would touch the courthouse with a 10-foot pole unless he's literally court-ordered to be there, which obviously he is going to be called as a witness. So There's no avoiding that, but I mean, there have been recent allegations of juror tampering, right? So as this court likely recalls, after they testified, members of the Albert and McCabe families proceeded to sit in the gallery with the O'Keefe family facing the jury sporadically throughout the remainder of the trial, including closing arguments. So I guess we didn't see it because I only really recall it just stuck out like a sore thumb, and maybe it's because they strategically placed themselves so they wouldn't always be on camera. But I don't maybe Carrie Roberts was there, but she wasn't actually even mentioned in this, so I am curious. I mean, Carrie Roberts, when you like, really has nothing to do with, other than the fact that she was there with, you know, Karen and Jen McCabe the morning of, but other than that, she doesn't really play a major role in all of this. So I don't know, but they definitely don't want the McCabes or the Alberts sitting there, and I can understand why. It definitely sends some sort of message, maybe not the innocent message that Paul O'Keefe is trying to make it seem like, oh, we're not buying into the defense's BS, but buy into this BS, right? Tomfoolery. So, following trial, a juror reported to Vanity Fair magazine that he or she felt it was utterly inappropriate. So yeah, not only was it in that affidavit that we just pulled up, but in following articles as well too, not just in Vanity Fair, it was also exposed in a Turtle Boy article as well too. So that the Albert and McCabe families were able to stare down the jury from their position in the courtroom gallery. Julie Miller, Karen Reed tells her story, part 2. One juror reported to Vanity Fair magazine that he or she felt intimidated by the presence of the Albert and McCabe families. I mean, yeah, he's totally Tony Sopranoing you. I mean, he looks like he wouldn't be afraid to break some kneecaps. That's all I'm gonna say. Calling their presence in the courtroom's small gallery facing the jury completely and utterly inappropriate, noting that the Albert and McCabe families were substantial focal points of the trial, especially Brian Albert and Jen McCabe. The juror noted how unbelievable it was that the families were allowed in to stare the jury down. Julie Miller, Karen Reed tells all, this was extraordinarily prejudicial to Miss Reed. So whatever the duck that was, that big black box of redactions, is extraordinary prejudicial to Miss Reed. So I don't know, maybe it also implicates something that Paul O'Keefe had said too. But I mean, as we just played in the beginning of this video, that clip, that was from a big televised interview that he had done. I forget what station it was, but it was with the local station. So I mean, admitting to it, I don't know. The alleged third-party culprits. So again, this goes into this motion that was also filed earlier today, where I believe the Commonwealth is trying to exclude the third-party culprit defense from the defense, being Brian Albert, Colin Albert, and Jen McCabe, right? All sat in the gallery directly facing the jury, which according to at least one juror was intimidating. An act need not be overtly threatening to be considered intimidating. So let's look at this little footnote. Courts have recognized that when a witness or person stares down a jury, that can make the jurors feel timid or fearful. Again, if Brian Albert was staring at you and you were about to head into jury deliberations, that would be the forefront of my mind, is like, I mean, is this guy gonna come up to me in an alleyway? Like, you really don't know. And apparently the jury was being followed, allegedly. This is what's being alleged in some of these potential jury tampering allegations that have been made recently. Defining intimidation as making timid or fearful inspire or affect with fear, or to put in fear for the purpose of compelling or deterring conduct. Intimidation by the aforementioned witnesses in context of this case took the form of staring down. Commonwealth versus Womack, Some more case law noting that the juror intimidation during a trial where jurors were were concerned to leave, as there were a lot of people just kind of staring down and making the jurors feel uncomfortable. Yeah, I mean, are they gonna go all like Tony Soprano with like the baseball bats and go bada bing bada boo to your kneecaps in the back alley when you're boarding the bus and going home? Who the heck knows? You don't know. You just don't know. So yeah, that could have a potential influence. And I feel like this is a really important thing. You know, yes, there are bigger points to be made. This is just another layer, adding another layer to all of the duckery that is. As previously noted, an individual does not need to do actual harm in order for an act to be considered intimidation. As the jurors heard through testimony, the Albert and McCabe families have deep connections and familial ties to multiple state police forces and local governments. I mean, yeah, we're close, but we're not that close. We're acquaintances, but like, we kind of know each other, right? It was a lot of like, yeah, well, I kind of know them, but like, I don't really know them, you know? In addition, Mr. O'Keefe, a Boston Police Department officer, was a part of this tight-knit law enforcement community. By sitting with the family of John O'Keefe and continuing to face the jury for parts of the remainder of the trial, at least one juror felt intimidated by what he or she perceived as the Alberts staring the jury down. The judge has broad discretion to order the sequestration of witnesses before or after their testimony at trial. A defendant has a constitutional right to a fair trial. Yes, not the Commonwealth, but the defendant, to be decided by an impartial jury, free from intimidation and undue influence. Given that at least one juror reported feeling intimidated by the presence of certain witnesses towards the end of the trial, Ms. Reed respectfully requests that the court exercise its broad discretion to issue a sequestration order excluding Brian Albert, Nicole Albert, Colin, Julie, Chris, it sounds like the Von Trapp family, Jennifer McCabe, like the Von Crack family, Matthew McCabe, and Brian Higgity Diggity from the courtroom before and after their witness testimony to prevent further prejudice to Miss Reed. What about Kevin from South Boston, though? I didn't see his name pop up on there. For the above reasons, Miss Reed respectfully requests that this honorable court exercise its broad discretion to exclude, say it again for the boys in the back, Brian Albert, Nicole Albert, Colin Albert, Julie Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgity Diggity from the courtroom before and after their testimony at trial. And I think this will go pretty much hand in hand with whatever is decided on that third party culprit defense. But on the other hand, the Commonwealth files a motion for offer of proof prior to defendant calling or summonsing the Norfolk District Attorney and victim witness advocate as witnesses and request for an order that neither is subject to a sequestration order. If you want to stay up to date with the latest going on in the Karen Reed case, make sure you hit that subscribe button. Make sure you hit the notification bell so you do not miss the next video from me. And make sure you hit that like button because that tells the YouTube algorithm that this is newsworthy news. It's important that we continue to spread the word and talk about the blatant corruption that is going on in Norfolk County. Period. End of story. But the best way that you can help is if you do have the money and you can make a donation to the Karen Reed Defense Fund, which I always link in my description box. I mean, she's almost at $750,000 raised of a $2 million goal. This girl is $5 million, probably more now, over $5 million in debt. And to my understanding, this cash is going to go towards the experts, the 12 experts that are going to be gracing the stage in a theater near you very, very soon. So this is how she is going to pay for those experts. Again, it's in my description box below. You can click that link, donate as little or as much as you can. I'm sure Karen Reed and her family would greatly appreciate it, and John O'Keefe as well too, because justice for Karen Reed, freeing Karen Reed, means justice for John O'Keefe, or at least one step towards that direction. So, with that being said, I'll see you in the next one.